Well, hello again. Let's talk about Chapter 7, the International Legal Environment, Playing by the Rules, from Katora et al., 2020. Okay, so in this chapter we look at the four heritages of today's legal system. We look at the important factors in the jurisdiction of legal disputes, the various methods of dispute resolution, the unique problems of protecting intellectual property rights internationally, and how to protect against piracy and counterfeiting. We also look at the evolving issue of cyber law, the legal differences between countries and how these differences can affect international marketing, and the different ways that US laws can be applied to organizations operating outside of the US. We end the chapter with the steps necessary to move goods across borders, geographic borders. Okay, so let's begin with foreign business transaction law. Now, the big issue with international marketing is that no uniform international commercial law exists. What we have is a disparate and complex system where the legal systems in different countries vary, and it's important to comply with the laws in each country in which a multinational operates. So we have four heritages of today's legal system. We've got common law, civil or code law, Islamic law, and commercial legal system. Interpretation of these four systems varies by country, and one way that we can look at this variation is through the number of attorneys per capita. So this graph shows us that in China and Japan, we have the lowest number of lawyers per 100,000 people, whereas in the US, we have the highest, and that is a reflection of the litigious society that America is. Okay, so common law is derived from English law found in England, US, Canada, and other Commonwealth countries that may be currently or previously under English control. This form of legal system is based on tradition, practices, and precedents that have been set through a court system. Then there's code law, which is derived from Roman law, and it's found in Germany, Japan, and France. These are non-Islamic and non-Marxist countries. It's based on an all-inclusive system of written rules of law, and there's three main codes: commercial code, civil code, and criminal code. And all laws are codified, but broad interpretations are actually possible. So when we compare and contrast common law with code law, we recognize that common law is based on tradition, whereas code law is based on a system of written rules. Common law is not all-inclusive, whereas code law has catch-all provisions with broad interpretations. In common law, ownership of intellectual property is based on use, whereas in code law it's based on registration. In common law, agreements are binding as long as you have proof of agreement. In code law, agreements are not enforceable unless they're notarized or registered. In common law, unforeseen occurrences of nature, such as natural disasters, for example, may well negate. And in code law, this extends to human acts, specifically, for example, labor rights and riots. I've got a typo there. Okay, then we've got Islamic law, or Sharia. This is based on interpretation of the Quran and specifies patterns of social and economic behavior for people with regards to property rights, economic decision-making, and economic freedom. The overriding objective of this form of law is social justice and equality, so they emphasize ethics, morality, social and religious dimensions. And Islamic law prohibits investments in activities that violate Sharia, such as alcohol and gambling enterprises. And we see this with this graphic about banking in Dubai. And banking in Dubai definitely requires an understanding of Islamic law and customs, because there is prohibition against the payment of interest and prohibition against investments in businesses that deal with anything to do with gambling, anything to do with alcohol, because that's two tenets of Islamic law, and it affects the banking sector throughout the region. Okay, if we move to talking about Marxist tenets, what we're talking about is a pattern for development of the economy that differs by countries found in Russia, Eastern Europe, China, and other socialist states such as Cuba and Vietnam. Marxism law is subordinate to prevailing economic conditions. So development of the commercial legal system is necessary, and that's the case for socialist countries trading with non-Marxist or non-socialist, non-communist countries. Now, if we turn to jurisdiction in international disputes, legal disputes can arise in three situations: when we've got disputes between governments, when we've got disputes between an organisation and a government, or between two organisations. Now, if we're talking about legal disputes between governments, then that will be resolved at the World Court at The Hague. And if we're talking about either legal disputes between a company and a government or legal disputes between two organisations, then that's handled by a court in one of the countries involved through an arbitration process. So jurisdiction is generally determined by the clauses included in contracts. It's also determined by where the contract was entered into and where the provisions of the contract were performed. In international dispute resolution, we have three approaches. We have conciliation, arbitration, and litigation. So let's look at each of those three. Conciliation is about resolving disputes by asking a third party to step in and mediate, and discussion that occurs during this mediation process is confidential. That means that it may not be used in future litigation or arbitration processes, but it's not legally binding. Then with arbitration, what we're talking about here is a disinterested or an informed party being chosen as a referee, and they determine the merits of the case, they make the judgments, and many arbitral centres have standardised procedures, but arbitration clauses require agreement on two counts, and that includes the rules and procedures of the arbitration and the agreement to abide by the outcome or the awards resulting from the arbitration. And it's important to note that this is legally binding in most countries. With regards to litigation, we're talking about dispute resolution through a formal court system. Now, most will try to avoid litigation because it's expensive, it's time-consuming, it may result in highly damaging public relations. There's also a fear of unfair treatment in foreign courts, and there's a difficulty involved in collecting judgment that may otherwise have been settled through an arbitration process. And we need to flag, it's public, so there's a loss of confidentiality. If we turn to protection of intellectual property rights, what we're talking about in the international context is a very special problem. So intellectual property includes global brands and trademarks that are used to symbolize a product or the quality of a product or a particular organization. And these aspects of intellectual property are highly valuable. They're amongst the most valuable assets for an organization. So they're important to protect, and they're a symbol that entices consumers to buy. And accordingly, organisations spend millions of dollars on establishing property rights. But of course, we've got the issue of counterfeiting and piracy, and it occurs in a wide range of industries, costs billions of dollars in lost revenue. And in the pharmaceutical industry, for example, counterfeit medications can actually be fatal. So what we're talking about here is collusion between the manufacturer and illegitimate sellers, and that collusion is what makes counterfeiting more possible. So some feel that the intellectual property regime has gone too far in terms of organisations and that it may actually hinder creativity. And an important point to note here is that there is some evidence to link terrorism to counterfeiting, not only in the US, where I've given you a hyperlink to, but in other countries such as Hong Kong, for example. Here we've got a list of the piracy rates for computer software. The highest rates of piracy for computer software come from Libya and Zimbabwe, whereas the lowest rates for piracy of computer software comes from the United States and Japan. There is much inadequate protection of intellectual property rights, and it may well lead to loss of legal rights in profitable markets. So patents, processes, trademarks, and copyrights, these are all aspects of intellectual property, and they're valuable in all countries, but the problem is lack of adequate protection against foreign exploitations. So organisations may lose their rights to their own trademark because somebody else has decided to claim those rights in a particular country, and so they have to buy them back. So effectively, the organisations are held to ransom for their intellectual property rights. And patent infringement is commonly used by competitors with no intent to compensate for the use. Now, when we again compare and contrast common law with code law, in common law, we mentioned earlier, ownership of intellectual property rights is established by prior use. So the first to use is considered the rightful owner, whereas in code law, intellectual property rights ownership is established by registration. So the first to register is considered the rightful owner, and use of the property does not matter. We do have three main conventions, international conventions for intellectual property rights, and these are designed for mutual recognition and protection of intellectual property rights, but how far do they go? We have the Paris Convention for the protection of industrial property, the Inter-American Convention, and the Madrid Convention. Other managerial approaches we have to the protection of intellectual property rights include traditional approaches that may in some way remedy the issue, but they're rather feeble. We've got engaging in local representation and diligently registering intellectual property rights with appropriate agencies. So, the standard approach. The pursuance of negation and alternative dispute resolutions. You can complain to authorities of the host nation, or maybe complain to domestic governments, even the World Trade Organization. But how far does that go? The answer is not far enough. Okay. Turning to cyberspace and cyber law and the unresolved issues we have in that regard. Essentially, cyberspace is unregulated space, and what legislation does exist does not address the uniqueness of the internet, because the internet is global in reach, but it has no political or geographic boundaries. The European Union, the US, and other countries are busy drafting legislation to address myriad legal questions not currently addressed by current law. But until complete, organisations are at risk and they have to rely on the host nation's laws. Now, I mentioned earlier that some organisations have been forced to buy back their rights, and we refer to this as cybersquatters. Cybersquatters, they buy and register website names, and they might use, for example, common descriptive nouns or celebrity names or variations on an organisational trademark. And what they're doing that for is to hopefully sell at a later time at a higher price. And they're effectively holding the organisations to ransom to if the organisation wants to buy back that domain name, that URL. Now, this picture shows potential customers visiting a Microsoft booth in Beijing, and Chinese bloggers using the service to post messages might type in terms such as democracy, capitalism, liberty, or human rights. And if they do, they get a yellow light and a computer warning. And the message reads, "This message includes forbidden language. Please delete the prohibited expression." Now, Microsoft, as a US company, has agreed to this censorship, explaining they justify it by explaining that they're following local law and that Microsoft still needs to provide a useful service to its Chinese clients. So that's how they justify it. Tax is another unresolved issue in cyberspace. So while traditional tax systems, the tax is incurred where the economic activity is happening, but with the internet, people can work from anywhere. And so when and where should these taxes be collected, and who is the tax collector? Another unresolved issue. We can also flag jurisdiction of disputes and validity of contracts with regards to cyber law. And while cyber law is being created, for now we've got two main issues to deal with: determining whose law prevail in legal disputes between parties located in different countries, and establishing contractual validity of electronic communications. So we have many countries working to address this issue. All right, marketing laws. Countries have laws related to marketing that are specific to the country, and laws may vary with regards to promotional activity, business development, product labeling, pricing, sales and distribution, and the laws will vary from country to country and from industry to industry. So it creates a serious challenge for marketers and international traders. There is hope of a common commercial code that can be applied across countries, and the European Union is leading the way in attempting to standardise law. Here we've got a tragic issue to address, and that's the sale of human organs. In the Philippines and other developing countries, you can buy a kidney on the black market for around $2,000. And while US laws prohibit the buying and the selling of the human organs, this black market trade goes on regardless. And you can definitely assume that these Filipino people have been paid far less than $2,000 for the kidney that they provided to the market. What about green marketing legislation? What we're talking about here is environmental protection that extends beyond pollution and hazardous waste. Green marketing legislation focuses directly on the environmentally friendliness of a product, and Germany is recognised for having the strictest laws in this regard. They highly regulate management and recycling of packaging waste. In Europe, this label, eco-label, may be familiar to you. It's available to organisations that are compliant with the criteria. So organisations have to qualify to use that label. Now, antitrust laws. US has been the main enforcer for most of the 20th century with regards to foreign country antitrust laws. So we're talking about competition issues here. Competition issues related to fair commerce. So price discrimination issues, supply restriction issues, full line forcing, these are things that are highly penalised. And other countries such as Europe and Japan are following the US as a model in that regard. When US organisations are trading in foreign markets, they are required to abide by US laws. And the home country laws, the US country laws, protect the US political and economic interests. So the US law holds true in foreign jurisdictions with regards to not only the organisation, but the organisational subsidiaries and licensees of US technology. So that means no paying bribes, no trading with the enemy, no commercial ventures that harm the US, and unauthorised boycotts are punishable. So in the US, there is this act called the Foreign Corrupt Practices Act. And this act says that it's illegal for US companies to pay bribes to foreign officials, candidates, or political parties. And there's stiff penalties if you're found to be participating in bribery. Bribery is still common practice, business practice in many countries. But US organisations are required to strictly adhere to the Foreign Corrupt Practices Act. And some argue that this puts the US organisations at a disadvantage when they're moving into a market where bribery, for example, is common business practice. Antitrust laws that US antitrust laws also apply in foreign markets, and there's two main reasons for this: to protect American consumers and to protect American export and investment opportunities against any privately imposed restrictions. So what we're talking about here is defense of US commerce against threatening foreign behavior. Now, with regards to anti-boycott laws, US companies cannot participate in an unauthorized boycott. They need to request to cooperate with a boycott. And this creates a challenge for US companies because US organizations will be punished and penalized if they participate. So this extraterritoriality of US laws causes much anxiety for foreign heads of states, and because US laws can actually interfere with economic or political goals of that state. Multinational corporations are held liable for activities that violate human rights, and that means, for example, doing business with oppressive regimes. And what happens is that lawsuits are brought to US courts by foreign countries. So while the US wants firms to become multinationals, there's more work to do with regards to conflict resolution. Turning to export restrictions and US policy on exports, businesses can export without a formal license, but there may be cases, certain situations where they need a license, such as commodities and US technical data, re-exports to other foreign destinations, and US origin parts that are used to build foreign products. Now, this is all controlled by the US Bureau of Industry and Security, BIS, B-I-S, Bureau of Industry and Security. And exports from the US have increased dramatically in recent years, and we know this from the data published by the Export Administration Regulations, the EAR. Export restrictions are in place, of course, to protect the US national security. Sale of products cannot affect US national security, and that applies again not only to the organisation, the American organisations, but also their subsidiaries and foreign licensees of US technology. And this responsibility extends to the final destination of the product. There's also restrictions on weapons of mass destruction that have been put in place post 9/11. So the US controls exports for a host of reasons, predominantly to promote and protect human rights, also to enforce foreign policy and address any national shortages. The exporter actually has the responsibility for making determination with regards to export requirements and licensing requirements. If an item can be exported, then the appropriate license must be acquired. And when do you need a license? Well, it depends on the product, and it depends where it's going and what it's used for. A general license is not subject to control by the Export Administration Regulation, and the general license will list the product, the value, and the destination, whereas a valid license must be authorised by the Export Administration Regulations, the EAR, and it may include specific limitations, and it's only achieved through a formal application. Now we have this special case of dual-use technology exports. So much of the electronic technology used in long-range missiles is dual use, and what that means is that it's technology that can be used for both military and non-military applications. And emphasising the point again that it's the exporter's responsibility to ensure the final user of the restricted dual-use products complies with the export restrictions. This picture is flagging that China successfully test-fired a new type of long-range ground-to-ground missile within its territories when tensions between China and Taiwan were happening. And China and the US, they have both shot down errant satellites with missiles. And so this is part of why we have this special case of dual-use technology exports and the extra export restrictions that apply. So when we're seeking to acquire an export license, there are 4 electronic services that facilitate and expedite the process. We have the ELAINE system, the Stellar system, the ERIC system, and the SNAP system. ELAINE is an acronym that stands for Export License Application and Information Network, and this enables exports that have authorization, exporters that have authorization to submit their license applications online for all economies, commodities, except supercomputers. And when approved, licensing decisions are conveyed back to the exporter via the online system. Then the Stellar system, which is the system for tracking export license applications, Stellar, System for Tracking Export License Applications. This is an automated voice response system that tracks the applications and can be accessed via touch-tone phone. It provides applicants with the status of their license and classification applications, and it's available 24/7. So it gives exporters the authority to ship their goods for those licenses approved without conditions. The ERIC system is an electronic request for item classification system, and this is a supplementary service to the ELAINE system, and it allows an exporter to submit commodity classification requests online to the Bureau of Export Administration. The SNAP system is an acronym for the Simplified Network Application Process, and it's alternative to the old school paper submission. It enables an exporter to submit, export and re-export applications, high-performance computer notices and commodity classification requests online. Acknowledgements of submissions received the same day, and export license and other validations can also be obtained online. So SNAP is one of the changes implemented by the Department of Commerce in moving to a digital system. All right, and there you go. That's Chapter 7. Thanks again. I'll see you in Chapter 8. Bye for now.